legal education, consultancy, research, and pioneering law reforms. It is determined to provide the best stimulating experience to the student to harbor and bring out the polished version of their talents, skill through its various events of both national and international prominence. Before we begin our inaugural session, let's spend a minute in silence to cherish the memory of our beloved Narayanan sir. Thank you all. Today, we are blessed with the presence of several esteemed personalities on this virtual dais. But before we invite them, we have a small video clip to welcome you all to the 13th International Conference on Role of Judiciary in Controlling Maladministration. That was indeed a great welcome. Leaders instill in their people a hope for success and belief in them. Positive leaders empower people to accomplish their goals. This statement is indeed true for all of us. We have Advocate Narayanan sir, Director, Kerala Law Academy Law College, Member, Bar Council of Kerala, Special Government Pleader, Forest, High Court of Kerala. We are all united here because of his effort, vision, and support. From the bottom of my heart, I invite Advocate Narayanan sir to officially welcome our guest into this inaugural session. Sir, please.
Honorable Mr. Justice Hurni Christoph, Judge Federal Supreme Court of Switzerland, Professor V. Sudesh sir, Dr. Yashomati Ghosh, and other dignitaries on the virtual dais and of the virtual dais, and all my dear friends, students, brothers and sisters. It is indeed a great matter of pride, and also it's my privilege to welcome all the legal dignitaries who have gathered here for the inaugural address. I need not speak anything on the subject for the reason that there is going to be so many technical sections and detailed discussions that are going to happen on the subject. As we all know, power corrupts, absolute power corrupts absolutely. So wherever there is power, the scope of it being abused is there too much. They have learned of ombudsmans, Lokayuktas in India. No, this is a phenomenon which is there all over the world. And so today's this international seminar, which focuses on the comparative role, will make us understand what is the comparative position all over the world, how various countries, various nations are able to control maladministration or abuse of power, how they are able to, and how successful they are. And that will be a great insight for all of us who participate in this conference. And I wish all the best for a very fruitful outcome for this international conference. Now let me proceed on to my duty of welcoming the guests here, the distinguished dignitaries. Then first I wish to welcome the chief guest who is here to inaugurate today's this international seminar. That is Honorable Mr. Justice Hurni Christoph. He was earlier Deputy Judge of the Supreme Court of Canton of Bern on the Civil and Criminal Division. Then his Lordship has worked as Deputy Justice at the Swiss Federal Supreme Court in the year 2020, and presently he is the Judge of the Federal Supreme Court of Switzerland. And Honorable Mr. Justice Hurni Christoph is an international figure and an eminent personality. We are very fortunate that that Honorable Mr. Justice Hurni Christoph has agreed to be here to inaugurate this function. And as we know, Switzerland is a leader in the world in respect of several indicators of human development and also of better governance. So we would be so much enlightened and enriched by the words of Honorable Mr. Justice Hurni Christoph. On behalf of all those present here and on behalf of the Kerala Law Academy Law College and on behalf of the Center for Advanced Legal Studies and ICLQ Law Academy, I extend to the Honorable Mr. Justice Hurni Christoph a very warm welcome to this function. Welcome, sir.
Thank you very much.
Now, to deliver the presidential address, we have another eminent personality, Professor Dr. Sudish, sir, who is a very close associate of this institution and personally very close to me, as I used to meet Dr. Professor Sudish sir on various occasions, especially in NOALS. He's a member of all the academic bodies there. Sir is having a long experience of teaching, of more than 20 to 25 years of teaching experience. Earlier, sir has served as associate research professor with Indian Institute, our premier institute in New Delhi, and has also served earlier, before that, has served as professor of law in Vivekananda Institute of Professional Studies, and an eminent research professor, has produced several research scholars, several doctorates in law, PhDs in law, and presently, sir is the professor of the University Law College, another prestigious institution, which is working directly under the Bangalore University, which is the University Law College of Bangalore. Sir, we are very happy that, sir, you are here for this function. On behalf of the Kerala Law Academy Law College, on behalf of the Center for Advanced Legal Studies and ICLQ Kerala Law Academy, and all those present here, I extend to you, sir, a very warm welcome. Thank you, sir. Thank you, sir.
Good morning and thank you, sir.
Welcome, sir. Next, we have Professor Dr. Yashomati Ghosh. She is here to deliver a special address. She's also a resource person for our conference here. She is a very prolific author. She has authored many books on various subjects of law, and her books on administrative law, legal ethics, professional law is very famous and widely read, and has published so many research papers. And presently, Professor Dr. Yashomati Ghosh is holding the post of associate professor of another prestigious institution of our country, the National Law School of India, University, Bangalore. We are extremely happy that we have Madam with us for this function. She has agreed to be here, spend her valuable insights and knowledge in this subject. And on behalf of the Kerala Law Academy Law College, the Center for Advanced Legal Studies and ICLQ Kerala Law Academy, and all those present here, I extend to you, Madam, a very warm welcome to this function. Welcome, Madam. Welcome, please.
Thank you so much, sir.
Now we have among us we have Professor K. Al Kumar sir, who is the Director, Students and Faculty Affairs of Kerala Law Academy, who is the main light or guidance or the main person responsible for guiding all the faculty members and students and for coordinating all these directions. So, though he needs no formal welcome to this function, still for the sake of formality. Sir, I welcome you to this function. Professor K. L. Kumar, sir, I welcome you, sir, to this function for the sake of formality. Now we have the principal of our institution, Professor K. Harindran, sir, a very active person of our institution. Professor Harindran, sir, is instrumental in coordinating all our activities and giving guidance, just like Al Kumar, sir, to the faculty members and to the senior professors. And as the principal of this institution, sir needs no welcome as such, but still for the sake of formality. Sir, I welcome you to this function. Professor Harindra, sir, I welcome you, sir. Welcome, sir. I also welcome Radhika RP, who is assistant professor of Kerala Law Academy, who is coordinating this function and who is also will be delivering our vote of thanks in this function. She is also one of the main coordinators of this function. I welcome Professor Radhika, madam, this function. Welcome, madam. And of course, I can see Dr. Dikshana Saraswati, the live wire of our institution, who is also running around to organize all the function. Welcome, madam, to this function. Now, finally, I welcome the most important persons in this function is the participants, all the participants I welcome, the faculty members of this institution, faculty members of other institutions, students, conveners, teaching, non-teaching staff, and all those who are present in today's virtual platform. I extend a warm welcome to all of you. Welcome all. Thank you. Thank you.
Thank you, sir, for your warm welcome. I take this opportunity to welcome you too into this inaugural function.
Thank you.
Now-
Thank you. Thank you very much.
Thank you, sir. Now, it's my privilege to invite Dr. V. Sudesh, Professor, University Law College, Bangalore University, who has more than 20 years of experience as professor in various institutes. He has secured PhD in labor law in 2005 and has authored several books. It is an honor and privilege to have such a distinguished personality on this occasion. I invite Dr. V. Sudesh, sir, to give the presidential address to this function. Sir, please.
Thank you. I hope my voice is audible.
Yes, sir.
Okay. Good morning to one and all. Advocate Dr.N.Narayanan sir, the director of Kerala Law Academy, and my dear friend for many years now. Honorable Justice Hurni Christoph, Dr. Yeshomati Ghosh madam, Professor K. L. Kumar sir, the principal of the college, Principal K. Harinath sir, and as Sir Nagaraj sir described, the dynamic hand behind this program, Madam Dakshina Murthy, esteemed members of the faculty, resource persons for the 13th International Conference, students, research scholars. Indeed, I'm very happy this morning to join you all in the 13th International Conference on a very important yet contemporary subject, role of judiciary in controlling maladministration in India, a comparative study. Well, friends, at the outset, let me state that we all are part of the administration in the sense that one way or the other, we are impacted by the administrative decisions. And insofar as the concept of administration itself goes, I think the root goes back to ancient history. From the time that we decided to organize ourselves into a society, the need for administration arose. And if you look at the historical perspective literature on administration, you will find, at least in India, from the time of Chandragupta Maurya, when Chanukya, the Kautilya as is known, wrote the Arthashastra. From then onwards, we have stressed on the importance of administration as a means of effective governance. Well, the present administrative system that we have, we may be safe to say that this is the outcome of a British legacy when they started the Indian civil service. Now, the main focus of today's international seminar is how maladministration could be controlled or is controlled by the judiciary. Before we speak about maladministration, I think we need to be clear about what is administration as such. Whether administration involves only narrow issues of day-to-day procedures in all public institutions, or whether administration involves the broader aspect of government, making law, the work of the legislature, executing the law, the work of the executive, and judiciary, whether it involves all these or a narrow-minded approach. Only then we'll be able to understand what is maladministration. But one thing is sure, the economic policies and regulatory framework for the country generally has to be implemented through good governance. So if you look at good governance, it has several aspects. And when you speak about good governance or governance, there is a debate whether you should only call governance or good governance, because governance, it is implied, governance means always should be good, effective. In that context, if you try to understand maladministration, we can say that it is an opposite of administration, that you are not administering anything. Anyhow, maladministration is a very large subject. It occurs wherever social organization exists, and it is not confined to the operations of the government or the state alone. The whole subject of the prevention and cure of maladministration by government officials embraces and involves consideration of a far wider field than that of remedies that are designed to put right an act of wrong or an act of maladministration. Because why I'm telling you this is, if you concentrate on maladministration as a larger aspect, then you need to focus on the procedure or the manner in which people are recruited, people are trained, people are given positions, powers by the government. So you have to look into the recruitment procedures, the training procedures, the moral commitment of those officers. So that's what I said. We need to focus whether you look at the day-to-day administration or maladministration or a larger aspect of administration. That's a point to be debated. I think I'm sure many of the research scholars would concentrate on that. We know there is a very, very great deal of administration by government officials these days. Your entire administrative, my students will remember the topic of administrative law. It starts with from cradle to the grave. From the time that we sought to have a welfare state, from the cradle to the grave, the government administers it. So it's a wide topic. We will be compelled, being lawyers, being researchers, to define maladministration. How do we define? Let me quote what Sir Edmund Compton, the first British parliamentary commissioner for administration, had to say on what is maladministration. He says, nobody can define, I quote, nobody can define maladministration in plain terms. It may be difficult to define, but most of us believe that we could recognize an example of it. If we saw it, we can describe it by examples. For example, you went to a government office to get some license, to file a petition or some inquiry. You did not find the person responsible to receive your complaint, receive your plaint on the chair. Is that the case of maladministration? So these are the way in which we understand maladministration. Someone demanded some money to give you some benefit. That is an example of maladministration. Keeping that in point, probably Sir Edmund Compton said that nobody can define maladministration in plain terms. we could only experience maladministration. Well, friends, in recent past, we have seen how the judiciary has been very active. And if we think that the judiciary has only been active in the recent past, we are again wrong here. Because if you look at the history of the jurisprudence of the Supreme Court in case of controlling maladministration in India, we could start from the time that the first PIL was filed in the Supreme Court of India. And if I can just quote one case, which I very fondly remember as a labor law student, it is the Asian Games case, the People's Union for Civil Liberties versus Government of India, Union of India, wherein workers were engaged and paid a differential wage, were paid less than the minimum wage. There was no facilities for the construction work, etc., etc. All these were sought to be cured by the judgment of the Supreme Court of India. From that particular landmark decision to various other cases where the Supreme Court has directed the prison officials to release all those convicts who have served their sentences. From that to a case where a victim of accident had to be taken to a hospital, to provision of legal aid. So many such cases gives us a rich jurisprudence of the judiciary taking care of maladministration. Let that be like that. As an ordinary citizen, what is our concern? As an ordinary citizen, we deal with officials at the local level, state level, central level. And we deal with small matters of obtaining a driving license, of obtaining a compensation. So if you look at maladministration from a larger perspective, then we are going to lose focus of maladministration, the lower, narrow perspective where the government and the citizen are in direct contact with each other. So my request is, effort should be to identify these narrow yet important, small yet important aspects of maladministration. For example, maladministration where the officer sitting on the chair, the executive sitting on the chair is discourteous, is unfair, seem to be biased, seem to be incompetent, seem to be ignorant. All these are cases of maladministration. How do we then take these matters to the judiciary? I'm sure these are not aspects of the higher judiciary at least to deal with. The answer could be, yes, we have different laws. The Right to Information Act is one such law, wherein such type of maladministration could be brought to the notice to the public, and there were various NGOs associated with this work. But then, whether obtaining information under RTA itself is a cure for maladministration, I'm sorry, no, because we don't take it further. So, friends, if you look at maladministration from a citizen point of view, let me give you two examples. Just very recently, last week in Karnataka, there was a public grievance. The public grievance was about all the farmers whose lands were notified to be acquired 20 years back. 20 years back, the lands of the farmers were notified to be acquired by the, I think it is the BDA, Bangalore Development Authority, to construct the ring road, peripheral ring road. And now notice has been issued to those farmers to file their objections. And these in 20 years, in these 20 years, the farmers did not have possession of the land. They could not cultivate. Maladministration. And now the acquiring authority is telling that they will give compensation not as per the Land Transparency Act, but as per their own legislation. Notice was issued to the grandfather, and the grandson is now appearing before the BDA Commission. Another example of maladministration is the railways notified that a particular agriculture land will form part of the railway track that they are going to lay down. They never did in 12 years. After 12 years, they're telling the farmers, you take back your land. We don't want your land because we have changed the route. What a case. Now the farmer is not getting compensation. The farmer could not cultivate in these 12 years. These are all very important aspects of maladministration which affects the common man. Therefore, friends, when you talk about control of maladministration, I think the control of maladministration should start at the grassroots level in the three-tier system that we have of governance. At the grassroots level, at the panchayat level, the maladministration or the elements of maladministration should be controlled. So therefore, I leave it open to this audience. I leave it open to all the intellectual assembled here to focus on such aspects of maladministration which can solve the problem of a common man. This constitution was designed to benefit the common man, not only those who had the power of law or the power of money or the power of authority to get the problems solved. With these few words, I thank the organizers for giving me a wonderful opportunity. I do not speak much because as a president, you're only supposed to be a president's role of being just the person who could initiate. There are others, I'm sure, Justice Christoph and Madam Yashomati Ghosh will draw more focus, more clarity of this issue.
Thank you, sir. Today, we are blessed to have Honorable Mr. Justice Herney Christoph, Judge, Swiss Federal Supreme Court, Lausanne, Switzerland, and we are delighted to have such an eminent personality and a well-known international figure in this conference. It is my greatest pleasure and gratitude to invite Honorable Mr. Justice Herney Christoph for the inaugural address. Lordship, please.
Thank you very much. I'm very honored to participate this morning at this wonderful conference that you have organized. I thank Dr. Narayanan and Professor Badesh and the whole Kerala Law Academy very warmly for this invitation, and Drs. Mudi Manan and Saraswati also for this very nice organization. It is a big honor for me to participate. That's the first time that I'm participating in an international Congress in India. India is, for me, from a legal point of view, very interesting because India is a much bigger state, of course, than Switzerland, but it is organized also as a federal state, as the United States are, and as also Switzerland is. Switzerland is a very little state, but it is organized also in a federal structure, and that's the reason why there, I'm sure, are some similarities from a legal point of view of the legal architecture of our legal orders. And I would like to present you a bit the Swiss judiciary, and while presenting the Swiss judiciary, I will go into details on how maladministration is how we fight against maladministration in Switzerland in front of or within the system of the judiciary. Can I share the screen, because I prepared some slides? I guess I have to press here, share, and can you see the screen?
Yes, sir.
Yes. Okay. You see this screen here. This is the court building. I welcome you to the Swiss Federal Supreme Court in
Sorry,
Lausanne.
sir. The screen
Pardon?
is not.
Ah, wait. You are screen share. You don't see the screen.
No, sir.
New share. Let me check again. You don't see the
No, sir.
the slide.
No, sir.
Okay. How can I do that? It says here that the screen is shared, but I try again. You don't see?
No, sir.
Okay. I'm trying to, yeah, you know, if it's not possible, or can I send you the document?
Absolutely, sir.
You know, I can send you the document via.
Yeah, please send it to us, sir.
To
We'll share it.
wait, where can I send it to you?
So can you send it to Dakshina Saraswati, ma'am?
To which service?
Through email.
To email, yeah, of course. And
or WhatsApp, you can send it through WhatsApp or through email.
Okay. I sent the document to to Dr. Mudimanan already by WhatsApp. Let me check. I send it again to WhatsApp or to Dr. Saraswati, huh?
Yes.
Okay. Okay, I sent it right now, but I'm continuing with my speech. Perhaps
We'll be sharing it. We'll be screen sharing it.
Perhaps in the meanwhile, we can you can somehow put it on screen. Yeah, what is the Swiss Federal Supreme Court? Just some words about the Swiss Federal Supreme Court. It is the supreme judicial authority in Switzerland. It constitutes the third branch of government. This is the judiciary branch. Alongside the Federal Assembly, which is the legislative branch, the Parliament, and the Federal Council, the executive branch. The Federal Supreme Court is the court of final appeal. It issues final rulings on disputes, on any kind of disputes that you can have, disputes among individuals, between individuals and the government. That's where our topic of today comes. Among the federal states, the so-called cantons, and also between the federal states and the federal authorities. And its decisions can be again appealed to the European Court of Human Rights in Strasbourg. That's an international supranational body, an organ of the Council of Europe, and the Swiss rulings can be appealed in a certain sense as far as violations of human rights are concerned. As in every country, as the highest federal court, the Federal Supreme Court has to ensure the uniform application of the law, federal law, by the lower courts. These are the so-called cantonal courts, the courts of the federal states and the federal courts, and it has to protect the citizens' constitutional rights. In the context of
yeah. Sorry for interrupting. We received your mail, so shall we share this? Okay.
I tell you then to go forward. Perhaps you can.
Okay, yeah. We are sharing it right now.
Yes, this is the building. Yeah, I can see it. Yeah. This is the building of the Swiss Federal Supreme Court in Lausanne, as I explained. And very important is that the Federal Supreme Court, as a Supreme Court, just this is the text. Perhaps you can provide that to the participants. It is basing its rulings on the facts that are established by the previous instance, and in general, the Supreme Court does just assess the correct application of the law and does not assess again the facts. This is very important. Just as about the organization, perhaps you can go forward to the second picture. We have also a second seat, which is in Lucerne. We have 38 judges, and we are assisted by 127 court clerks, and we are based in 2 locations. Lausanne is the court's headquarters, and Lucerne is the second location, and it demonstrates the a consideration for the principles of Swiss federalism and multilingualism. So the courts, the Supreme Courts, are not based in Bern, which is the capital city, but are based in Lausanne, which is a French-speaking city, and Lucerne, because we do not want to concentrate everything at the same place. This is for respect for the federalism and the multilingualism. Now, why do we have two houses? The headquarters in Lausanne house the two public law and the two civil law and the criminal law divisions. I come then to these divisions because it's important also when talking about the fight against maladministration. In Lucerne, we have the so-called social law divisions. So in Switzerland, when it's about welfare, about the welfare state, when you have issues with the welfare state, these issues or these disputes can be brought in front of the social law divisions in Lucerne. Perhaps you can go to the slide where we find the structure of the court. Yes, the next one even. Exactly. Here you see that how the Supreme Court is organized. We have a court assembly where all the 38 judges come together, and they come together twice per year to discuss novel issues of law. And if not, we are adjudicating our cases in one of these 7 divisions. We have a first public law and a second public law divisions. I come to the question of what they deal with, but these public law divisions are very important when it comes to the fight against maladministration. We have the civil law divisions. They are obviously not that important when it comes to administrative law, but they also have some secondary function. Then very important is also the criminal law division, of course, because maladministration can constitute a crime when you have, for example, a breach of the secrecy of the administrative secrecy, or if you have corruption that amounts to a federal offense, then this can be brought to the criminal law division. I'm currently sitting in exactly this criminal law division. I'm dealing currently with criminal law, although from my background, I'm more a private lawyer, but it is always like that. When you are elected to the Supreme Court, you start in a division where there is a free slot. So that's where I started my service at the Supreme Court. Then we have the social law divisions. And perhaps you can go to the next slide. Why is the Federal Supreme Court divided into these divisions? It is because Switzerland is a civil law country. We make a division, a very clear, distinct division between public and private law. Public law deals with provisions concerning the organization of the state, the basic rights, the human rights, and administrative rights. Meanwhile, the private law governs the relationship of individuals, also corporate law in the economy, society, family law. That's a private law. And then some violations are punished by the criminal law. Now, each division of this Federal Supreme Court focuses in several specific branches of law. And now I come a bit to these two public law divisions. In Switzerland, if you have a dispute with the administration, if you are not happy with how the administration treated a matter, for example, let's say taxes, let's say some for example, the issuance of a driving license, everything can be brought in front of a court. And at the highest level to the Supreme Court, if the matter has a certain importance. So we have, for example, the first public law division, which deals with guarantee of ownership, national and regional spatial planning, construction law, environment protection, political rights, international judicial cooperation in criminal matters, traffic, citizenship, and so on and so on. The second public law division deals with the rights of foreigners, taxes and duties. So tax law is a very important, of course, matter because two things are certain in life: death and taxes. And if you are not happy with your tax bill, you want to go to court and so that the court assesses if the tax has been correctly calculated or not. Public commercial law, for example, subsidies, radio, television, freedom of religion, conscience, freedom of language, and economic freedom. That's dealt with the public law division. In the civil law division is important, perhaps, when we talk about maladministration, tort law. So if the administration constitutes a wrongdoing that amounts to a damage, then you can bring that via a civil suit in front of a civil law division. Then, as I already talked about the criminal law division, if maladministration amounts to a criminal wrongdoing, you bring it forward. Perhaps you can quickly go, I see that I'm running out of time. Perhaps you can quickly go forward to the next slide. Yes, perhaps even the next, even that these are the structure of the civil proceedings. More important is perhaps in our context, not the next, but even the following slide about administrative proceedings. Perhaps you go, yeah, one more exactly. There I can explain you. Perhaps you can go exactly this slide. Here I can explain you a bit how the administrative disputes are brought into the Swiss judiciary. You have, for example, a ruling by a cantonal authority. A cantonal authority means an authority of a federal state. Then you can appeal that at the cantonal level, and every canton has a specialized administrative court. This administrative court's ruling is appealable in front of the Federal Supreme Court. So the Federal Supreme Court is establishing a uniform practice over also the federal states' administrative matters. When you have a ruling by a federal authority, you can go to the so-called Federal Administrative Court, which is a first instance federal court, and from there you can go to the Federal Supreme Court. I guess I have already exhausted my time. I wanted to tell you some trivia about Switzerland, but perhaps you can provide the participants with these slides. So I don't want to steal more time, and I thank you very much and for the time that you granted me to present some aspects from Switzerland to your conference. Thank you very much.
Thank you so much, Your Lordship, for your valuable time of words and words of wisdom.
Thank you.
Now we have Dr. Yashomati Ghosh, Associate Professor, National Law School of India, University, Bangalore. She has authored several textbooks on administrative law and legal ethics and has also published and presented a variety of papers. I take this opportunity to invite Dr. Yashomati Ghosh for the keynote address. Ma'am, please.
Thank you so much. A warm good morning to all of you. I'm really thankful for being invited to this prestigious academy. This is my first time I am virtually and otherwise participating in any event of Kerala Law Academy, but I've heard so much about this institution that it is my honor to be here this morning. Thank you to all the organizers and particularly Professor Harindran for inviting me to this event. At the outset, I must appreciate the fact that for choosing this particular topic, because I think, administration has been a very, very important part of any Indian citizen's life. And it is so much connected to law as such. But any form of academic discussions with regard to administrative functionings has been almost pushed to the periphery. There has been so much focus on other aspects of constitutional law, federal structures, fundamental rights. But this is an area of study and research which has been kind of totally ignored. So being a student of administrative law myself, I really appreciate the fact that this has been chosen as a topic for an international seminar to be organized on this area. The chosen sub-themes are quite fascinating, and I'm sure over the period of the various paper presentations, many different aspects will come out. One point I would be like to shortly discuss upon is something where Professor Sudesh has kind of laid the framework, laid the foundation for this particular event, wherein he emphasized on the part of the role of administration and the significance of it. The other aspect of administration which largely affects us is corruption, which is an integral part of what we would largely connote within the context of maladministration. India has been considered to be a country which ranks quite high as far as perception of corruption is concerned. As per the recent data published by Transparency International, India ranks as high as 85th nations among 160 countries. And what is also very interesting is the fact that when you read this particular report, what you find is that almost 40% people have definitely said that they have participated in actual act of corruption. But what is all the more striking is the fact that almost 90% of the participants have said that they perceive the government to be corrupt. So the perception about corruption and the perception that government is corrupt, that is something which is definitely worrisome for everyone. Honestly, when we talk about incidents, if we look at across the globe, corruption has been a matter of concern for the entire global community, for the entire international business community, the United Nations, the OECD, World Bank, every organizations from 1990s onwards have been emphasizing significantly about the scale, the massiveness about corruption. India has its own history of corruption. But when we look into the global context, it may not be of such a high nature. What India probably has got something which can be said to be in the nature of petty corruption. There are major scams which have happened in India, but largely it is the petty corruption. If some of you are following what is happening in South Africa, the trial of President Zuma, and the kind of what they call a state capture form of corruption, which involves administration and political authorities, then business authorities, businessmen, and the kind of interrelationship which exists and which has given rise to the massive scale of corruption and maladministration in South Africa is something which is, of course, an eye-opener for most persons. Almost for 9 years, under the rule of President Zuma, corrupt practices and maladministration at different levels in different ministries were captured. But what is also striking is that, like, how in South Africa, this entire corruption, the fact that the administration, the political authorities were not working properly, and the exposure which came out of that, I think it's a learning experience for all of us, is the fact that the South African Constitution provides for something in the nature of a public protector, an office, an independent office of public protector. And this public protector brought this to the attention of the general public about this entire incident. And then the South African Supreme Court took it upon itself to conduct the inquiry. And not only that, when the non-cooperation by the then sitting president had happened, they did not hesitate to even issue a contempt order against him, which led to the imprisonment of President Zuma and subsequently the trial which was happening. So I think for us, it is important to recognize that the corruption and maladministration as a fact exists. But at the same time, what is also important for us to look into the various institutions which are existing in a society and what kind of citizens' role is expected from the common persons, which might bring us wherein we can face such major challenges. India, if we have to look into it, there have been many incidents. A few years back, there was a book written by eminent journalist Chandan Mitra, who had described India as a corrupt society. Of course, it's a debatable point whether we can even label ourselves as corrupt society. But what he tries to bring about is that it is not a question that, the administrative failure is something which might be, is more in emphasis post 1970s, post 1990s, economic liberalization has brought it. But rather he emphasizes that historically, just like Professor Sudesh mentioned about Kautilya's Arthashastra and the role of the administrative officers. At the same time, the same Kautilya also speaks about corrupt officials, how they affect administration and administrative functioning. And this is also reflected. Some of you who have done legal history would know the trial of Warren Hastings, impeachment proceedings, and wherein from historical past, the concept of corruption, maladministration was something which has been brought to us. Post-independence, there have been various incidents wherein we find the linkage between administration, politicians, business, and something which automatically comes to our mind is the Mundra scam, wherein how public money from the Life Insurance Corporation was used at the instance of the then finance minister to fund and pay back on certain business enterprises of a private individual. And this had raised hue and cry at that point of time in the Indian Parliament, which forced the Prime Minister Jawaharlal Nehru to conduct inquiry, asking a sitting Supreme Court judge, Vivian Bose, to take up that particular thing. So there has been, what I'm trying to emphasize is that this issue about failure on the part of the administration and failure on the part of public entities, and thereby pushing other organs of the state, whether it is the legislature or it is the judiciary, to step in and trying to ensure that certain amounts of probity in public life is maintained. And that is something which I think is the most crucial aspect, which we need to deliberate in the present context. Another important point which I would like to emphasize is the fact that administration and the failure of the administrative authorities somewhere is being pushed. The accountability of the failure of the administration is being pushed towards the doors of the judiciary. But I think that is something which we need to relook. Like, why should it be that all matters of administrative failures, corruption, should at all reach the doorsteps of the Supreme Court? Why should it be that the judiciary has to always, the higher judiciary always has to step in by virtue of the power of judicial review and intervene in matters which are particularly questions of administration Our administrative authorities should be made robust to such an extent that the system itself is able to take care if there are certain aberrations. And I think this conference is an opportunity for the young participants to look into those alternative approaches, because it is a fact which we cannot deny, is that accessing higher judiciary, whether it is the High Court or the Supreme Court, is almost impossible for an ordinary citizen. The cost involved in approaching judiciary, even filing a petition, unless and until there is some kind of a support which is otherwise existing, it is almost next to impossible. The cost of litigation is very, very high. So it is important that we need to look into the existing systems, mechanisms of good governance, the existing bodies like Lokpal, the Anti-Corruption Bureau, the Lok Ayukta. It is very, very unfortunate that after all the political pressure which was imposed on the parliamentarians by civil society groups in 2011, 2012, and finally the enactment of the Lokpal happened. But it took so much political apathy was there that even the appointment of the Lokpal had to be delayed by several years. And even now, when we have something in the form of a Lokpal sitting there to look into questions of maladministration, corruption, and matters of that sense, there has not been a single proceeding which has been initiated by the Lokpal, and which entirely brings out the failure. It cannot be a society it cannot be a situation where there are no complaints made. Of course, complaints are being made. But the point is that there is a lack of will on the part of the people in the positions to take up this thing. In this kind of a situation, what I need to emphasize is that there is a very, very significant role which the members of the legal profession has to play. We talk about professional ethics among lawyers, but I think lawyers as not only client representing, but also people who participate in functioning of the administration, people who participate in business organizations and deciding business activities, they have a very, very important role to play, wherein it is important that they make the distinction between what is legally permissible and what is ethically wrong or morally wrong as far as actions are concerned. So this is something which needs to be done. It is not to say that other countries do not face issues of corruption. Of course, US, Japan, there are multiple complaints with regard to corruption. But the only reason why those countries may not be perceived to be corrupt is because that they have institutions in place. Wherever there is a reporting made, immediately action starts taking in, which I think has been a failure in Indian context. That we have many institutions. Lack of institutions is not the problem, but the will in the authorities to act, to take a complaint seriously, and thereby to ensure that acts of maladministration and corruption are immediately taken care of. That is something which does not happen in a regular basis, and that is the reason prosecution and number of cases pending on under the prevention of corruption laws is so very high. With this, I would not like to take any more time in this inaugural session. I warmly appreciate the effort made by Kerala Law Academy in taking up such an important topic, and I wish them all the very best for this event and all the future events. Thank you so much.
Thank you so much, ma'am, for your valuable words. Gratitude is not only of the greatest of virtues, but the present of all others, says Cicero. I welcome Srimati Radhika RP, Assistant Professor, Kerala Law Academy Law College, and one of the faculty conveners of this international conference, to give the vote of thanks. Ma'am, please.
Thank you, Megha. As we express our gratitude, we must never forget that the highest appreciation is not to utter words, but to live by them. Quoted by John F. Kennedy. A delightful good mornings to one and all. Honorable Mr. Justice Hernie Christoph, Judge, Swiss Federal Supreme Court, Lausanne, Switzerland. Dr. V. Sudesh, Professor, University Law College, Bangalore University, Bangalore. Dr. Ashmati Ghosh, Associate Professor, National Law School of India University, Bangalore. Advocate Dr.N.Narayanan Sir, Director, Kerala Law Academy Law College, Member, Bar Council of Kerala, Special Government Pleader, Forest, High Court of Kerala. Professor K. Alkumar Sir, Director, Administrator, Students and Faculty Affairs. Faculty members, students, and dear participants. Today, on this auspicious occasion of 13th International Seminar conducted by Kerala Law Academy Law College, in association with Center for Advanced Legal Studies and Research on role of judiciary in controlling maladministration, a comparative study. With great enlightenment and pleasure, let me undertake the duty behold to me by extending gratitude to all those who made this event to reach its zenith forthwith with the presence of creditable personalities. Maladministration has an effect on the effective commitment of government, and a system negatively pressurizes it to manage the financial resources effectively in order to meet the development mandate. It makes the system ungovernable, unreliable, and irresponsible. A good governance signifies the way an administration which improves the societal standards, sustaining a responsive judicial system which dispenses justice on merit, unfair, biased, and meaningless manner, and maintaining accountability and honesty in each wing or functionary of the government. This 13th International Seminar conducted by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research on role of judiciary in controlling maladministration, a comparative study, aims to enlarge the awareness and its relevance among individuals engrossed in law. Taking this event further, I would take to move on to my duty born to me. I take it as a great honor to thank Honorable Mr. Justice Hernie Christoph, Judge, Swiss Federal Supreme Court, Lausanne, Switzerland. He is a well-accomplished scholar who was a lecturer of civil procedure at University of Bern, Deputy Judge at the Supreme Court of Canton of Bern, Civil and Criminal Division. And he was a researcher and teaching assistant at University of Bern. I take this opportunity to extend my sincere gratitude towards you, sir.
Thank you very much.
We are extremely privileged to have you with us today. Thank you, sir. Now I take this opportunity to thank Dr. V. Sudesh, sir, Professor, University Law College. University Law College, Bangalore University, Bangalore, who has a teaching experience of 20 years and had worked at many reputed law colleges and had been successful research guide, who is also an author. I would like to express my sincere gratitude to you, sir. I would like to thank from the bottom of my heart Dr. Ashmati Ghosh, Associate Professor, National Law School of India University, Bangalore. She is a great academician who has received many awards and fellowship and has so many publications. I would like to express my sincere gratitude from the bottom of my heart, ma'am.
Thank you so much.
And now I would like to thank Advocate Dr.N.Narayanan Sir, Director, Kerala Law Academy Law College, Member Bar Council of Kerala, Special Government Pleader, Forest, High Court of Kerala, a man with charismatic personality and extreme energy who is our support core and a standing pillar. I would like to express from the bottom of my heart my sincere gratitude to you, sir. Professor K. Alkumar Sir, Director, Student and Faculty Affairs, Kerala Law Academy, for being the master brain behind every event and for always being a great mentor. I would to thank you from the bottom of my heart, sir. Professor Harindran K., our beloved principal, has been our strength in all our academic and other allied activities. I would like to thank from the bottom of my heart, sir. And nothing would be possible without the wholehearted support and guidance of some strong-willed, determined people behind the curtain. You all together made this international seminar a successful and informative one. I express my immense gratitude to our faculty conveners, student conveners, and volunteers for our tireless effort. And I finally express my regards to all the participants. Last but not least, I thank each one of you present here for your kind cooperation. Thank you. Thank you all.
Thank you, ma'am, for expressing your heartfelt vote of thanks to this inaugural session. I use this opportunity to extend my gratitude to you too, ma'am. And now we have reached the end of this inaugural session. This is all on behalf of Kerala Law Academy Law College, and I thank all of you for joining and remaining with us till the end of the session. This is Megha Manoj signing off. Once again, thank you all.